So, Renato, how badly did Lindsay Halligan screw up this Comey indictment?
It's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm the author of the Freedom Academy Substack.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet. Wow, Asha, talk about something that can't be boiled down. There's so many errors, so many mistakes, so many missteps here. It's just, we could spend hours going through them all.
Yeah, I like to think of this case now as the Comey choose your own adventure. Because I feel like there are so many, if you want Comey to have his indictment dismissed because of selective and vindictive prosecution, turn to page 36. If you'd like to, see it dismissed because Lindsay Halligan was not legally appointed, turn to page 52. So there's like all these different paths, and we talked about some of them, right? We've talked about the challenges to Halligan's appointment because of the ways that the replacements for interim U.S. attorney works by statute. We've talked about the selective and vindictive prosecution piece, but this is a wholly different adventure, which is about what a magistrate judge called prosecutorial misconduct in front of the grand jury, and in not just in front of the grand jury, but even in the way that this case was investigated. It's almost, there's a lot to unpack, and I think we should go into it.
Yeah, I agree. So Comey was essentially indicted for statements that he made in 2000, the year 2000, in a congressional hearing in which he referred back to testimony that he had given in a prior congressional hearing. And it's worth noting that even there, he's referencing the truth or falsehood of things that he said in that congressional hearing. It's really a way for the DOJ, Trump DOJ, to try to prosecute Comey for something that was far beyond the statute of limitations. And even this attempt to jump through hoops to do that was running up down to the wire. I think it's actually an important piece of the story here is I believe the indictment came 18 days before the statute of limitations expired on this 2000 testimony, because you have to prosecute people within 5 years, generally for most federal crimes, of when the crime occurred. And here they're really prosecuting him for saying something and referring back to testimony from far earlier about things that happened even before that. And the reason I think the reason I'm offering that context, Asha, is that one of the things that happened here is that the DOJ did not, it turns out, conduct a proper investigation. I feel like we've already talked about the fact that they got rid of the former U.S. attorney left, thought there wasn't enough evidence, and we have kind of this person here of questionable legality, her appointment. But another issue is Mr. Comey was investigated before during Trump 1 for something totally different. And they didn't prosecute him back then. And instead of opening a new investigation here and gathering evidence and doing things the right way, they didn't have time for that. So they basically tried to cut corners and take evidence that they obtained in a search warrant in a prior investigation back in 2019 and 2020 and use it in this case, even though there's no reason why you would think they would have legal authority to do that.
Yeah, I think we need to unpack this because this was kind of shocking to me.
Yes.
So what this order from a magistrate judge, which came down about disclosing grand jury transcripts to the defense, explains is that in 2017, Renato, as you said, the U.S. Attorney's Office for the District of Columbia opened an investigation which was called Arctic Haze, which finally makes sense to me because I've seen like a lot of these like right-wing people referring to it, and I didn't fully understand what it was about. But it was about essentially potential leak of classified information that he used when he announced the closure of Hillary Clinton's investigation. So the FBI in 2019 and 2020 got 4 search warrants, which authorized FBI agents to search various devices belonging to Daniel Rickman, who's a Columbia Law professor and a friend of Jim Comey, and importantly, later becomes his attorney, starts to represent him. Those search warrants authorized the FBI to search for information related to 2 crimes: theft and conversion of stolen government property, or unlawful gathering or transmission of national defense information. And it was authorized to allow for the collection of information between in a particular time period, and a part of that time period actually overlaps with when Rickman started to represent Comey. So there's so many problems here. So just to begin with, so first of all, it looks like even in those search warrants, the government actually got way more information than it was authorized by the warrants themselves in terms of like the time period, et cetera. Then once they got it, they didn't actually go through to essentially screen out any potentially privileged information. And they also didn't notify Comey that these potentially privileged communications were in this whole pile of stuff. So those are all problems just from the get-go. But as you said, Renato, what happens is when this new investigation is opened, which is for, as you noted, something completely different, because there were no charges ever brought on those 2, theft and conversion charges that they got the search warrant for. They didn't get a new search warrant because they thought it was going to take too long. They were like, hey, we have all of these emails already. Hey, FBI agent, look at this drive of all, whatever hundreds of documents, and pull out anything that is related, is an email between Rickman and Comey. And so they just went through on a fishing expedition in these emails that they already had from a completely separate investigation, and pulled out, a bunch of communications, which they then relied on to create this whole new case.
Yeah, let me just explain why.
I was just about to pause and say, I feel like this could be like a law school issue spotter exam. So maybe you can kind of explain where the red flags go up for you, even from the beginning.
Well, on this specific issue, I mean, there's a lot of different issues here. You built in the whole privilege thing, which I was sort of going to put to the side, but that's its own separate set of issues. But one thing that I think it's important for our listeners to understand is when you get a search warrant, you actually are presenting to the judge evidence in the form often of an affidavit that a law enforcement officer makes, an FBI agent, for example, detailing and describing evidence and laying that out in front of the judge. And you're specifying a specific place and specific things you're going to search for. So I might say, for example, I am going to get a search warrant for Asha's house. I'm going to search for the books behind her. I know that those books exist because I have seen them on this YouTube video I watch on Midas Touch Network. I know they're there, and I believe they constitute evidence of a crime for whatever reason. Okay, so I am authorized to search a specific place and get these specific things. Why am I starting with a physical location and physical things? Because that's how search warrant jurisprudence develops.
It has to be polarized.
Right. It was not about emails. Okay. It's about searching somebody's house for stuff.
Yeah.
Okay.
The places and things to be searched is the wording of the Fourth Amendment.
Correct. And so the point being that when we go to emails, we treat those, we get warrants, search warrants to search emails, which is appropriate. That's not only what courts have decided, but that makes a lot of sense in terms of the logic of the Fourth Amendment, that you want law enforcement to go to a judge and get a warrant. Okay. But what happens in that circumstance is you go to the judge and you say, I want a warrant to search this Gmail account for these things. I want the emails from this specific time period to search for these items. The judge approves and signs that search warrant. And then you send that warrant in this hypothetical, okay, to Google. And because they operate Gmail. When you do that, then Google sends you a disk potentially, or they send you a drive or a file through its secure file transfer that has a copy of this person's, in this case, let's say Comey's Gmail account. The purpose of that is for you to execute the warrant. In other words, to search for the specific things authorized, to look for evidence of the specific crime set forth in the warrant. So having evidence that was that to basically take this is the equivalent of if I went into Asha's home and took some of her books and things that you see behind her and gathered them as evidence, but instead of destroying them at the end of the case or returning them to her, which would be the ordinary thing, or then otherwise destroying them, I kept them. And then I'm like, I suspect Asha of doing something totally different. And instead of opening a new investigation and getting a search warrant of her home, I'm going to take all this evidence that I have, that I gathered because of this prior case, and I'm going to start looking through it.
Yeah.
That's what it's like.
Right. And I would say in that initial piece, you also have an obligation when you first take those books to make sure that any books you do keep are specifically related to what the search warrant authorized and what you told the court you were going to take. And so here, it doesn't look like, it looks like the FBI just kept all of these emails that, first of all, they didn't even narrow it down to whether they didn't determine what they were keeping was even related to those original two alleged offenses, but they just hung on to it. So you're saying that they should have destroyed it, I guess, right? I mean, in the intelligence world, we call it minimizing, so you would discard it.
Well, you usually, if it was a physical item, you would return it at the end of the investigation. Okay, that's often the case. Hey, I got a bunch of your stuff, right? Yeah. From your warehouse. But in the digital context, a lot of times this stuff is kept, Asha. At the end of a file closing, you're going to put, put a bunch of CDs or different things in with your stuff that you put into the, and they're kept for X amount years, 20 years or something, or X number of years. I don't even remember. I had to fill out these forms saying how many years they're kept. But the point is, what you don't do is initiate an investigation, separate investigation about different crimes, and then just start looking through the stuff that's in records.
Well, I mean, I asked that because the magistrate judge suggests that they kept it for longer than they should have. So whatever that time period is, so not only did they have evidence, materials that went beyond the scope of the warrant, they kept it for too long. And then it's this issue of this seems pretty obvious to me that it would be a new search. If you have a new crime, and even if you are in possession of things that you need to go back and get authorization to then go and dig through to find evidence of another crime. That to me, I think, seems like a pretty obvious Fourth Amendment violation. It sounds like, though, what the government was trying to argue is that even if that's the case, that the remedy for Comey is not that the indictment would be dismissed, but that he would just move to suppress any evidence once he went to trial.
That's right. And to me, that's an interesting one, but there's an argument that can be made, right? That ultimately the government, the testimony was public. The government could have investigated there. As long as they're not using that evidence, then that is sufficient. Now, I want to just touch on the privilege issue that you raised and then you mentioned, because I think that's important as well. So Mr. Rickman, who you referred to previously, is an attorney. He has served as an attorney for James Comey, is my understanding. And the government, it didn't appear, had any protocol set up to have a taint team review that material. And what I mean by that is typically what happens in law enforcement is you gather all this stuff let's say documents from a warehouse or from an email account. And you have a separate team that's unrelated to the investigation review those records and then cull out anything that's privileged, put it off to the side, and only give the investigators access to privileged material. Here, they went through the privileged material. And then because they didn't do a proper step of initiating a new investigation and getting a new search warrant, what they actually did is they took that taint and they brought it to the new investigation by having the same agent, FBI agent from the first case, come in and testify to the grand jury about the second case and have him basically, they're like, oh, you did this entire investigation. We're going to repurpose that for something else.
Right. And this is the other part that Comey is now arguing and why he wants these grand jury transcripts, because he says this agent that testified and provided evidence was exposed to potentially privileged communications that form the basis, that even if he didn't reference those communications specifically, that the government has relied on it indirectly even to essentially create the theory of the case. I mean, there's no way to show that it didn't. I mean, it reminded me when I was reading it of why there can be complications, for example, when Congress grants immunity to people who testify and then they're prosecuted later, because there's no, it can become very hard once things are out there to kind of extricate whether, you relied on it or not, right? I mean, the defense. And so, I mean, and that's why you have that taint team, so that there's no question that that was all sequestered from the people who actually create the case and testify.
So I'm going to make a hot take. So we've talked about a number of problems with this case. We've talked about her appointment. We've talked about this whole fact that they didn't get a search warrant to search the stuff is kind of a big deal. The fact that they're going through privileged material and tainting themselves there. I actually view these as tier 2 problems in the level of problems that this case has. I actually think here, another hot take. I'm going to give you what I believe, and I think it's not the headline, but I think it's the biggest problem with the whole thing and the cleanest way for the judge to get rid of this.
Okay.
It is the statements that this prosecutor made to the grand jury. So let's just talk about how grand jury works.
And you called this, Renato, you called this a few weeks ago, where we were talking about how Lindsay Halligan might have screwed the pooch in the grand jury presentation, and you called this. So go ahead.
Yeah. So when you go in front of the grand jury, it's a group of ordinary citizens. They only interact with the prosecutor. There's no one else there. There's no defense to point out the other point of view. There's no judge there. There's no rules of evidence. There's a court reporter, a bunch of random citizens, and then the prosecutor who runs the show there and puts everything in front of them. She can bring in an agent, like a witness, and she'll ask the agent questions. She can provide documents to the grand jury for them to review. But her job is also to instruct them on the law and then explain to them why the evidence that they presented demonstrates that the government has presented sufficient evidence to indicate that there's probable cause to believe that the defendant committed the particular crimes charged in the indictment. Now, in the course of doing that, what I had previewed at the time, I didn't think she was potentially going to get all of that right because she's not an experienced criminal prosecutor. And, one topic that you talk about all the time, Asha, a phrase that you love is I think the presumption of regularity, how we presume that things are happening the same way. Well, with somebody who's never handled a criminal matter in her life, never prosecuted a case before, knowing what to do in the grand jury when there's no one working with you, no one teaching you, no one demonstrating it to you is remarkable. So like when I was in first one in grand juries, I actually went and observed the first time. And then I had somebody with me, a supervisor, when I first was presenting inconsequential indictments, unimportant indictments, that if I screwed up, it wouldn't have been the end of the world, potentially. Someone counterfeited $5,000 of U.S. currency or something like that. It would have been okay. So in this case, she said two things that I think are very problematic and are so obviously problematic that I think the judge could toss the indictment in a very clean way. The first is she suggests, and I think the more important of the two, I'm going to start with the more important. She suggested that there was other evidence that the grand jury hadn't seen that's better out there, and that the grand jury doesn't have to base its determination on the evidence placed before it, but instead could consider the fact that the government probably has better evidence and is going to present that at trial. I mean, that's just like, honestly, what's so bizarre about that, I feel like that flies in the face of common sense.
Yeah, that like the whole point of the grand jury proceedings is to present the probable cause.
Yeah, I think my mom or my wife would have figured that out. They're not lawyers, but they would have figured that out.
Yes.
Yeah.
And it sounds like, by the way, that she in for both of these things that the court highlights, that it's in response to questions from the grand jury.
Right. She probably had somebody in Washington, like
Todd. They don't. So people should know, like in this magistrate judge's order, it doesn't say exactly what she said. So you're kind of like, I mean, it says why they're problematic. So we know, what she's essentially, what the jurors were led to believe. But it also sounds like she's responding to questions that they had.
Right. I think that's a good thing to note, Asha. First of all, to explain why we're not being precise about her words, but also because you have to imagine that somebody probably gave her a script to tell her exactly what to say. She probably had somebody who was more experienced than her, maybe somebody in the main justice in Washington, who kind of go through and explain her exactly what to say. But these were off the sheet. These are off the script. The grand jurors ask questions. And usually they have none because it's so obvious and so straightforward. Yep, he was caught with 2 pounds of meth in his hands or whatever. But in here, this is a complicated case and kind of a thin read, if you might want to put it kindly. And they had a lot of questions. And one of them, I think, went to a kind of fundamental issue. And it just shows how incredibly incompetent she is, that she didn't understand the fundamental nature of the proceeding, which was for the government to present its evidence to the grand jury for them to determine whether there's probable cause. The second thing that she misstated, which was remarkable, because I feel like anyone who's watched television shows should know this, is that she misstated the fact that she said Comey would not have a Fifth Amendment right not to testify at trial. In other words, I guess we don't know what the grand juror asked, but presumably they're like, well, is he going to have to be forced to explain which of these things is true or something along those lines? And she suggested, yes, he would probably, as what sounds like from the context.
Yeah. It says the prosecutor's statement that blank, redacted, may have reasonably set an expectation in the minds of the grand jurors that rather than the government bear the burden to prove Mr. Comey's guilt beyond a reasonable doubt at trial, the burden shifts to Mr. Comey to explain away the government's evidence, which, as you know, I think this kind of just, as you know, gets back to these like fundamental tenets of criminal law that honestly, like, even though she's an insurance lawyer, I would think that she knows this. She should know this.
Yeah, just like anyone who's watched TV shows.
The bar, you need to know this.
Yeah, it's just like sort of like I said, non-lawyers would know that. I bet if you quiz people, most people would know this. I think the first one that was so important, Asha, because I think you could have the reason I say that, and I want listeners to understand, I'm not saying any of this other stuff isn't important, but there's complicated elements to that where this is very straightforward. Like the prosecutor told the grand jury they could consider things outside the evidence presented to them when returning the indictment. So this indictment's invalid. If you find a way to issue another indictment, I'll consider it at that time. Bye. Could be a very, very straightforward, easy, hard to attack order by a judge.
What you were saying is that the prosecutor's own statement concedes that they have not provided sufficient probable cause.
I'm saying we can't be sure that the jury returned this indictment based on the evidence presented before it, because they were told to consider other things that are outside the four corners of the evidence. It's sort of like
they're told to trust her that there was going to be more evidence,
right? And that, like, but that's like,
if it's not enough right now, there'll be more.
That's a huge problem, because the jury could have done it because they just are like, well, there's not enough evidence, but we hate this guy. or some impermissible reason, and we could never know because the prosecutor explicitly told them, you do not have to consider the evidence. In other words, you often have cases, Asha, where the prosecutors are arguing the evidence before you,
Right.
You should at trial. And then the jury says in interviews afterwards, yeah, we didn't think there was enough evidence, but we hated him, or whatever whatever they say. And you do a lot of magic thinking that hey, they were instructed to do the right thing. Here, they're instructed to do the wrong thing, to ignore the evidence and just vote based on faith. And that's, I think, very easy for the judge to issue a decision based on.
Okay, so then can we get to the last crazy part?
It's even more interesting and complicated. Why don't you explain that one, Asha?
Yes. So I think even what we're looking at for this purposes of this podcast is an order that was issued by a magistrate judge, giving his reasons for requiring the government to turn over the grand jury transcript to Comey, to the defense, because it meets the requirement. There's enough evidence of irregularities and potential misconduct that the defense is entitled to see it. That order was stayed by a federal district judge, in this case, Judge Nachmanoff. And that judge had a hearing today where he questioned more about the issues, or at least definitely the issue I'm about to talk about, but has not yet issued a final ruling on it. So it's some of the facts surrounding this are still kind of blurry. But basically, what we do know is this, that there were basically two documents that were returned. The first one indicated that the grand jury failed to find probable cause as to any count. There were originally 3 counts that were presented to the grand jury. A second indictment indicated that the grand jury found probable cause as to 2 counts. Now, at the time, both of these were presented in court. The judge said, okay, this makes no sense. What's happening here? And I think the judge was told that, well, the grand jury only voted to find probable cause on 2 counts, basically used this second document, it sounds like. And so on the first document, there's a handwritten notation that basically tries to reflect the fact that the grand jury voted for 2 counts, even though the text of it says the exact opposite. The reason this is important is because it looks like that second document that is, kind of lays out the charges against Comey, the 2 charges that the grand jury said they voted for, were actually not presented to the grand jury. In other words, they returned this first document. I don't know if they figured out that the document, somebody had screwed up or whatever, but it looks like she huddled with the foreman of the grand jury for 7 minutes, kind of came up with this new fix-it document and went into court. And so the actual charging instrument, the charging document, was never formally presented to the grand jury, and they did not vote on that. That is what appears to be the issue here. And it seems like a technicality, but it's also kind of a big technicality, it seems like.
Yeah, a few things on that. I mean, at least based on reporting, what you're saying is not just what it appears to be, but that is what has been said in court, according to reporters. Okay, that she has indicated that the final indictment, the indictment that's operative in this case, had never been voted on by the grand jury. Okay, now what happened was, and I think it's worth noting, that there were questions raised by the judge in the case about the timing of things and whether the judge had the full record of everything that had happened here, because the time did not match with what Lindsay Halligan had said. And the judge really was pushing on this. There's a declaration by her that I think, if you look at it in retrospect, knowing what we know today, rights around, in other words, finds creative ways to answer the question without getting to this fact that the particular indictment was never presented to the full grand jury, if you look at it. But basically, it's fair to say the DOJ lacked candor, in my opinion, did not come forward and just put this issue in front of the judge. The judge ended up, through diligence and a persistence, nailed them on this issue and found this issue. And you could tell from the comments that we're seeing from reporters who are reporting what the judge said, the judge is wrestling with this because it's an issue that, to his understanding, has never occurred before. And this is what I want everyone to understand what this issue is, so we get it. Often indictments contain more than one charge in them. Okay, we call them counts 1, 2, and 3, whatever. Usually the grand jury just agrees with the prosecution and everything because the system's set up that way. I've already described it to you. If they don't agree with a particular count, the right way to handle it would be to write up a new indictment without that count in it, present that indictment, show them the old one, show them it's exactly the same, represent to them it's exactly the same, but I took out count 9 that you didn't like or count 3 that you didn't like, and we put all the same ones. Have them vote on that, the new one. And that's what prosecutors would typically do in any case.
So
she didn't do that.
Just to ask on that, though, so if you did originally present 3 and they didn't agree on 1, would the normal practice be that they would then say they failed to return an indictment on any of the counts, and then you would have to represent it? Or is there any way that in that first go around, because what they try to do here is also reflect on that first document that they, this was written in after the fact and by the foreperson, that they did vote on only one, or they only failed to return an indictment on one of the counts.
So I want to give some context here for our listeners as to this. I worked in one of the largest U.S. attorney's offices in the country. I think Chicago, next to L.A., because it's one county for the whole city, was the biggest. They were the biggest U.S. attorney's offices. I think once a year we'd have no bill from the grand jury, maybe. I don't know. It was almost never. It was like a big deal when somebody didn't have their indictment returned. It was like embarrassing. And I don't know if we ever had one with just one count returned that way. So I'm telling you what I would instruct.
How you would handle it to make sure that there's no issue.
Correct. But I don't know. I mean, the reality is that, and this would be my take on this one. This is the reason why I voted the other one. My hot take was the other one was more clean. I do think the judge may be right that this has never come up in a court case. And I think almost never you have a grand jury reject one count. If it ever happened, the prosecutor would probably just present a whole new indictment, or it would never get raised because there'd be like 18 different counts. Maybe one got crossed off, but like the person was clearly guilty of drugs or whatever it was, robbing a bank. And so they pled guilty and it just never became an issue. And candidly, I think if this was Chapo Guzman and there was 36 counts and one of them was rejected by the grand jury and they didn't present the final 30, the judges would probably find some way to kind of keep it all together.
I think the problem is that the original, the actual wording on the original document that came back, that was supposedly reflected the grand jury's proceeding, says that they failed to return an indictment on any of the counts. That was then corrected by hand. After.
Yeah, I think the argument is actually the argument is somewhat technical, but it's core to the constitutional protection because
exactly
in the Fifth Amendment to the U.S. Constitution, it says that no person shall be held to answer for a capital or otherwise infamous crime, in that's interpreted by courts to mean any felony, unless on a presentment of or indictment of a grand jury. And the argument is the grand jury never approved these charges, and we don't know and we can't be sure what they did approve. And so accordingly, the whole thing's over on this technicality. That very well may be right. And I will just say that argument is better than the argument that federal criminal defendants have in like 98% of cases. But it's not the best. I just think there's so many problems with this one. It's like you said at the beginning, a choose your own adventure, that there's so many different ways in which this is screwed up.
Yeah. And some other former feds that, I was in communication with suggested that this is not fatal.
Yeah, I mean, that's what I said. If in
that
another
and this is why the Judge Enactment Office actually, I think, is going to review the transcript again, because maybe if indeed it's in black and white that they voted on these two, and it's really about some printing screw up or something that didn't reflect actually what happened in those proceedings, and I could see maybe it being okay or something, or the judge not. I don't know.
Yeah, like I said, if this was like the Jeffrey Epstein indictment, okay, just some infamous criminal, okay, that's what I'm saying, Chapo Guzman, he's like, international drug cartel guy. Yeah, whatever bad person you are thinking of in your head, and they had done a lot of crimes and there's some procedural screw up. I will just tell you, as somebody's practiced criminal law for 20-something years, the judges would find some way to not let the person go free in that circumstance. This is an interesting circumstance because there's so many other problems. He's been targeted. The president is putting, photos of him with an X through him after this indictment on his social media. There's all sorts of issues here. And I think a lot of judges presented with this are going to be like, what's the cleanest way to get rid of this thing? And that's why I'm like, the fact that the prosecutor told him, don't just focus on the evidence, focus on other things, I think is like really clean. That's a real problem. In combo, you could say with combo and all this other stuff.
Well, I mean, the magistrate judge lays out 11 things that are seriously wrong with this. So I think, to your point, it's like a choose your own adventure within a choose your own adventure. Because just on the investigation and grand jury piece alone, I will say that it seems to me, I think that this adventure, whichever grounds is chosen, would be the strongest of kind of the three big buckets. Like, selective and vindictive prosecution is kind of an uphill battle. And I don't know what the standard of review would be, but they would appeal it. And, I think there would be a lot of deference that's given to the government, especially if there's like a colorable case under it. The Halligan appointment, that's something that it seems like would definitely like go all the way to SCOTUS, because it would get to, the executive's power, et cetera. So it does seem like this whole quagmire it's hard because so much of it is about fact finding. And I would think that the lower court's findings would be given a lot of weight. Like, it would be like clear error or abuse of discretion or something like that.
That's right. And Asha is referring there to the standards on appeal, which I agree with you with. And I just think something that is hard to justify or very clear cut is just easier. I think so. I wouldn't be surprised if there's a ruling here on a number of different grounds, but I think we can safely say that the trial of James Comey is not going to occur anytime soon. There's going to be a lot of appellate litigation about this, and wouldn't surprise anyone if this indictment ended up going away. So, Asha, I don't even know. We spent all this time talking about all these problems with Comey. I don't even know if that was the biggest misstep made by the Trump administration this week.
Yeah, I almost used my nuclear Elmo meme earlier this week when all of those Epstein emails dropped.
Yeah, it was amazing. And I have to give credit. I'll just say on the front end, I have been over the years a close friend of Ro Khanna, and we were roommates in law school. I have not talked to him actually for some time, and I have not discussed this matter with him. But him and Thomas Massie, the Republican, really managed to take it to the Trump administration here and do something that's pretty remarkable. I mean, it is very rare for a discharge petition to ever succeed in the United States House of Representatives. A. B. It's very difficult, very rare for the House of Representatives to rebuke Donald Trump or go against Donald Trump. And he saw the writing on the wall, and he had to admit, after saying it's a hoax and everyone should vote against it, he had to admit defeat. And it's really something when you have diehard MAGA folks resisting Trump pushing them to do something. And to me, one of the things that, perhaps you'll disagree with me on this. I actually think there's a bit of a profile in courage here when you had Lauren Boebert brought it to the Situation Room to have the screws put on her by the Trump's closest cabinet members and so forth. And why they choose the Situation Room, so you can't record it, so you can't do it. God knows what they were telling her in there. And she stood her ground. And they had the votes. They tried to put the screws on Marjorie Taylor Greene. Trump went after her, went after Boebert. They stood their ground against Trump. Well, I thought that was remarkable.
Yes, it is remarkable. And to clarify, so the discharge petition is for the Department of Justice to release its information, but there were emails that were released that were provided by the Epstein estate. I'm not really sure what the story is there, but somehow the estate gave a tranche of documents to members of Congress, which then, they released out, which has all kinds of stuff in it, which I think, what we've already seen just from these emails that have come from the estate is that I think one thing that's very obvious is that Ghislaine Maxwell clearly lied in this, performative interview that she did with Deputy Attorney General Todd Blanche, because there are things in there that directly contradict. I mean, number one, I think it directly contradicts things that she was saying. I don't know if you look at the specific wording of what she said, maybe it's not directly a lie, but it also raises the question of why he did not. I don't think it raises the question. We know the answer, but I'm saying it highlights that he did not aggressively question her in order to actually get to the bottom of anything real. Now, what Todd Blanche has said on social media is that he was not, he didn't have these emails. He's like, those are not, those are from the estate. We didn't have these emails. So, those would not have been, he couldn't have based his questions on them. But that to me seems really sketchy. I mean, this is somebody who has been, Jeffrey Epstein has been the subject of 2 federal investigations in 2 separate jurisdictions. Then Ghislaine Maxwell was a subject of an investigation, and both Epstein and Ghislaine Maxwell were charged. Why would the Justice Department not have had these communications also in their possession?
Yeah, they've got terabytes of information, I'm sure.
Right. That made no sense. Okay, so I just want to point that out, that these are not things that were technically in the Justice Department's possession. And Todd Blanche claimed that he didn't have them, but I think it's pretty clear that if he had looked, they would have been somewhere in there. But what would be released by the Justice Department is potentially even more of this. And so I think, Trump has now said he's ordered the Justice Department to investigate some of the people that are mentioned in at least some of in what has been made public so far that came from the estate, people like Larry Summers. He's mentioned Bill Clinton, though I have not seen any communications between Clinton and Epstein. But interestingly, he doesn't seem to think that Steve Bannon or himself needs to be investigated, even though he's mentioned more than anyone. And so I think it does raise the question of, Trump has kind of gone along with this because he, as you mentioned, he knows that the train has left the station. I think that there is a possibility that then now the Justice Department is going to say, no, we have ongoing investigations, so we can't release any of this information.
So if you look at the text of the bill that just passed the House of Representatives, and my understanding is from what you had mentioned to me at one point that the Senate passed it today. It says permitted withholdings. The Attorney General may withhold or redact segregable portions of records that would jeopardize an active federal investigation or ongoing prosecution, provided that such withholding is narrowly tailored and temporary. So that, I think that's they're just going to say that they're complying with the statute. and they're just going to redact.
But that language does say it's segregable. So you can't, in fact, if anything, that seems like a backfire, right? Because you ordered the Justice Department to investigate all these Democrats. According to that language, they have to release all the records except those pertaining to those Democrats.
You would think. I mean, and then here's the kind of accountability mechanism here is that within 15 days of completion of the release required under Section 2, the Attorney General shall submit to the House and Senate Judiciary Committees a report listing 1, all categories of records released and withheld, 2, a summary of redactions made, including the legal basis, summary, not total, but a summary, and 3, a list of all, quote, government officials and politically exposed persons named or referenced in the release materials with no redactions permitted under subsection B1, close quote. I don't know 100% what that means, politically exposed persons, but the bottom line is this is their mechanism to try to get around this problem. And I'm not sure. I have the feeling
mechanism to get
this is the way that Massey and Khanna, in constructing this, are like, okay, we see what they're going to do, so we're going to force them to put a report. And I think they may be underestimating how devious the Trump administration is, because I think that they will find some way to summarize, quote unquote, this in a way that sort of obscures the truth.
Well, they've handled it so poorly, they're just going to make it worse. Now, I have seen on Blue Sky people saying, oh, the FBI is scrubbing the files and, like there's some deletion or shredding going on. I just don't think that's the case. Like these are the case files at this point are digitized. I mean, they're a part of a system. I'm not a IT person, so I don't know, but I would think that if that was something they could have done, they would have done it by now. I don't think there's a way to actually remove these from, a government record keeping system. Definitely not within the FBI. And I just don't think anybody would go, like any agents, would go along with that.
I mean, to me, Asha, the most interesting thing about this isn't even the specifics of what's in the records, although I'm glad that they're being released because there's so many questions and there's so many victims that want to know the truth of what happened and uncover people who were enabling the perpetration of these very, very heinous crimes. But I think it's the way in which Trump was checked here, the schisms that are developing within his own coalition. I think it has broader implications potentially for democracy. I'm hoping that this isn't a one-off.
Well, I mean, it definitely gets to transparency. It gets to some of his potentially waning power because he is a lame duck, really. I think this also gets to a really interesting phenomenon, and we can talk about this in another podcast, but about how different identities trigger different loyalties, right? When people are feeling like their loyalty is MAGA, when an issue implicates that particular aspect of their identity, they're going to be very loyal to Trump. But one thing, like if you notice, people have other strong identities. So people have strong identities as, for example, anti-vaxxers. If you remember back to Trump 1, when he came out in favor of the vaccine and encouraged people to get vaccinated, there's a whole part of his base that revolted. And it's because that particular identity trumps, no pun intended, their MAGA identity. I think the Epstein files, like kind of this quest for truth to pull back the curtain of the Epstein files and finding the pedophiles and all of this kind of stuff. I think that's a very strong identity that many people have, particularly those who've gone down like the QAnon rabbit hole and, within MAGA, that also trumps their MAGA identity. And that's what I think you see with people like Marjorie Taylor Greene and Lauren Boebert, who, they are willing, they are more loyal to this cause or this community or whatever they feel they're a part of over even Trump himself. So he is not, I mean, it takes a lot. I think it takes, these other salient communities and identities, but it's interesting that this one has superseded their loyalty to him.
I think it's fascinating and important and something we're going to have to watch for weeks to come. So, Asha, before we go, I heard you've had a birthday last weekend.
I did. I had a birthday on Saturday.
Happy birthday.
Thank you. Thank you. I actually was doing college visits with my daughter. And then we stopped at Princeton and hung out with my son. We went to the Princeton-Yale game, which Princeton lost. And then I went to see the Triangle Show that night, which is a theater group that I was a part of. And they had their show this weekend. So it was really fun with my kids.
Yeah, super cool.
Yeah. When is your birthday?
July 3rd. Oh. So it's always celebrated.
That's right.
And in the middle of the year. So it's sort of in between, in between Christmases, which is kind of nice.
Okay. Well, when we get there, we'll celebrate.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.